John Risvold for plaintiff Cipriano.
Is that Riswold or Griswold?
Risvold, R-I-S-V as in Victor, O-L-D.
Thank you, Mr. Riswold.
Your Honor, J.C. Cotterill, representing Dorothy Byrne and Dorothy's Bar and Grill.
Thank you. Calling first witness.
Plaintiff calls Officer William White.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to the best of your ability? I do. Please proceed.
May I proceed?
Proceed.
Would you please introduce yourself to the jury?
My name is William White.
And Mr. White, what do you do for a living?
I'm a police officer in
And
the
how
city of
long?
Meade.
How long have you been a police officer?
About 10 years.
And how exactly are you involved in today's case?
Well, the evening of the incident, I was on patrol and received a call and responded to the scene.
Objection, Your Honor. Narrative.
Sustained. The jury will disregard this witness's immediately prior testimony to be stricken from the record. I believe your last question, Counselor, was, how are you involved in this case?
How are you involved in today's case? Yes, Your
In
Honor.
this case, you want to try that again?
Officer White, on the night of August 14th, did you receive a call to respond to a bar fight at Dorothy's Bar and Grill?
Yes.
Objection, Your Honor. Leading.
What rules?
And did you begin an investigation in that case?
I did, yes.
I'm sorry, Counselor.
Would-
Officer White, I didn't hear your answer to the first question.
On the night of August 14th, you responded to a call at Dorothy's Bar and Grill.
I did, yes.
And when you responded to that call, what did you see?
I got there and Mr. Cipriano was laying on the floor unconscious, and it looked like there had been a fight.
Did you have a chance to speak with the defendant, Dorothy Byrne, that evening?
Yes, I did.
And when you spoke with the defendant, what did she tell you?
She told me
Objection,
that...
Your Honor. Hearsay.
Your Honor, it's a party phone admission.
Anything to say to that, Counselor?
Your Honor, we haven't established that there's any type of admission, so I would have to object to foundation on that point.
I'm reversing myself. It almost never happens. But your objection is overruled. Please ask the question again.
When you spoke with the defendant that evening, what did she tell you?
She told me that there had been a fight between two patrons at the bar, and she described the fight to me.
Did she tell you that she had been involved in the fight in any way?
Yeah, she said that she broke the fight up.
And how did she say she broke the fight up?
I believe she said she struck the one individual with a bat, Mr. Cipriano, I believe.
Of your investigation, did you collect any evidence from the scene?
I took a bat from the scene and a beer bottle.
The baseball bat that you collected from the scene, would you recognize that bat if shown to you today?
Possibly. It looks like a bat. So,
Permission to approach with what has been pre-marked as Plaintiff's Exhibit 1.
Approach. Has defense counsel had a chance to inspect the plaintiff's?
Right. Now, officer, I'll give you a second to look that over. Do you recognize what I've just handed you?
it's a baseball bat.
And how do you recognize it as a baseball bat? Just briefly describe it as you're holding it for the jury.
Well, it's made out of wood, and it looks like what I usually see baseball players using to play with.
Thank you, officer. Now, you said you collected a bat from the defendant. Does that bat appear to be the same or substantially similar to the bat that you collected from Dorothy Byrne?
I can't say it's the same exact bat, and it looks similar.
Does it appear to be the same make and model as the bat that you collected? Or substantially similar to it?
It's It's pretty close. I can't say for sure. I don't recall exactly what the make and model of it is.
Does it appear to feel the same weight as you felt from that bat?
Sure.
Appear to be the same length or substantially similar length?
Yeah, it's similar.
And does it appear to be substantially similar to the same condition that the bat that Dorothy Byrne turned over to you?
I suppose so.
At this time, Your Honor, we offer Exhibit 1 in evidence.
Objection, Your Honor. Relevant.
May I be heard, Your Honor? It's a simple form.
Now your turn, Counsel.
Yes, Your Honor.
Ms. Cottrell, relevance.
Yes, Your Honor. It hasn't been established that this is the bat. We're not bringing in a demonstrative piece of evidence just to show what a baseball bat looks like. This is supposedly the bat that was used to strike the plaintiff in this case. The officers clearly testified that he can't identify it as such, and there's no chain of custody that's been established. So I'd have to object to this piece of evidence as admission.
Anything else you'd like?
Well, I would also like to say that I find it prejudicial, Your Honor. There's no probative value. It's been agreed in the depositions that the plaintiff was struck with a bat, and this bat has no forensic evidence on it whatsoever.
For the purposes of the jury, understanding that the plaintiff was struck with a bat, it's important that they understand what that bat looked like, felt like, what size it was, how much it weighed. The fact that this bat, in and of itself, is substantially similar to the bat that he handled is important, because we don't know if it was a 35-ounce bat, a 36, 38, a 42-ounce bat. How long was it? Was it aluminum? Was it wood? These are important characteristics that the jury needs to understand. And because this officer has previously handled the bat and can testify that this bat is substantially similar, it really doesn't matter if it's the exact bat that was used. We're not trying to match ballistics here. We're trying to give the jury an understanding that he was hit with a wooden bat that was 34 ounces and 32 inches, rather than an aluminum bat that was 42 ounces and 40 inches.
Your Honor, I would have to argue that, number one, we haven't certified this officer as an expert in weights and measures, able to discern a 1-ounce difference months after the incident. So I think the difference between a 34, 35, 36-ounce bat is immaterial at this point.
Counsel, I'm going to make my ruling. Mr. Griswold, you've undone yourself describing exactly how the officer could fully describe the characteristics of the particular baseball bat that we don't have. This isn't the bat. The jury knows what a baseball bat looks like. Even I know what a baseball bat looks like. So, a baseball bat will not be an answer. Now, if you choose to ask additional questions, don't have the witness refer to that bat.
Yes, Your Honor.
If you choose to ask additional questions of the witness, that's fine. The motion is sustained. That doesn't come out.
Yes, Your Honor.
Thank you, Your Honor.
Permission to approach and retrieve the exhibit.
Please.
And I have no further questions for this witness at this time.